SJC-12040, Commonwealth v. Frank Valdez.
Good morning, Your Honor.
Wait. We're not quite ready for you. Save that thought, Mr. Kramer. Don't lose it. Okay, now.
Thank you. Good morning, Your Honor. If it please the court. My name is Attorney Scott Kramer, and I represent Frank Valdez. This is a case where Mr. Valdez was convicted of receiving a stolen motor vehicle in 1989. In 2014, he filed a motion to vacate that pursuant to Chapter 278, Section 29D, sometimes known as the Alien Warning Statute. A hearing was held, and it was determined that the trial judge, or the plea judge, while he did advise about deportation and he did advise about naturalization, he could not say that he advised about exclusion from admission. In the paperwork filed in conjunction with this, Mr. Valdez asserted that he would like to travel out of the country. He has friends and family in the Dominican Republic that he would like to visit.
Can you tell me, the conviction for this crime will result in his exclusion, is that correct?
Absolutely.
And would it also result in his deportation?
It will if and when they get around to it, absolutely.
So 27 years later, they haven't gotten around to it?
Correct.
All right, but you're saying it will, it is the basis for all of those things?
It's the basis for all of those things, Your Honor, yet because he was warned about deportation, that is not squarely at issue.
Yeah, but it seems to me the tail is wagging the dog here. It seems to me what your client really wants is to get rid of this conviction, so A, he won't be deported, and B, he might actually be able to be a naturalized citizen after spending 27 years here or more, and says, well, I want to travel now. Doesn't that seem a little odd?
Your Honor, first of all, a couple things on that comment. First of all, I would say that enforcement is a lot different today than it was 10 years ago, 15 years ago, and certainly before 2001, and even beyond that, before 1997. So, first of all, the enforcement is getting worse. Absolutely, he would like to avoid being deported. Absolutely, he would like to maybe someday being a naturalized citizen. But in terms of his desire to leave the country, I suppose what you're suggesting, Your Honor, is that that suggestion is not credible.
Well, and here's the deal. If we can get this conviction vacated, then I'm clear on the things that are really important, which is not being deported and being able to become a naturalized citizen, as opposed to a vacation in Costa Rica or something. I don't...
But I would suggest, Your Honor, respectfully, that the bar to establish that one may want to leave the country, really, the bar that may suggest that one may be excluded if he does leave the country is not a high bar. First of all, people travel out of the country all the time. They do it for personal reasons, for vacations, to visit family, to visit friends, which was specific in this case. They do it for religious pilgrimage, whether to, the Vatican or Jerusalem or Mecca. There's a lot of reasons why somebody may want to travel. Maybe they just want to go on see the Canadians play the Bruins in Montreal.
Has your client been out of the country since he's been here?
That is not established on the record, Your Honor. I don't know.
Not in the record, okay.
So let's assume he goes to the Dominican to see his family, and he comes back, he goes to passport control in Logan upon his return, correct?
Yes, Your Honor.
What happens?
What would happen, what should happen, and overwhelmingly likely will, unless there's just an error on the part of the Department of Homeland Security, he will be detained, he will be taken into custody. Now, if it's Logan, hopefully he'll give me a call. If he returns to, let's say,
Miami, so let's assume it's a connecting flight in Miami.
If it's Miami, he's got a problem, Your Honor, because he's going to likely be detained in Miami. He could be brought to any part of the country, and he's going to face a proceeding that's going to be done far before he can gear up an attorney to file a motion to vacate, all the while being unnecessarily incarcerated, and it's overwhelmingly likely that he would be incarcerated.
Isn't it overwhelmingly likely on the same analysis that he could be deported?
It is, Your Honor.
And the difference, it just seems, is that the deportation requirement, the other two things as to which he was warned and he knows are the sort of Damocles hanging over his head. He has no choice about those.
That's true, Your Honor. That's the problem.
He has a choice about it.
That's right, Your Honor. And by including exclusion from admission in the statute, I would respectfully suggest that the legislature is suggesting that it is his choice, that he may have a good reason to leave the country, and may have, we talk about burdens of proof all the time. There's, of course, beyond a reasonable doubt, there's fair preponderance. May have is the slightest of proof that something may happen. It's not that it's a certainty. It may happen. It's a possibility. May indicates possibility.
Does he have a U.S. passport?
I don't believe so, Your Honor. I
probably.
believe he's...
So coming into the country, he would be coming in as an alien.
He would be coming in, when you leave, he is a Dominican citizen, so when you leave as a Dominican citizen who is a legal resident, you come in and I believe there's some indication that you're a legal resident. You go in the pre-screening, they do their computer checks, and if they find that there's this case, they're going to give you a secondary screening and detain you. But I believe he would travel on his Dominican passport.
Okay.
Well, the difference, though, between deportation and exclusion sounds like in deportation, they would have to make an affirmative decision to find you.
That's correct, Your Honor.
And under exclusion, they have to make an affirmative decision whether to admit you.
That's right, Your Honor. That's exactly the correct point. And to put yourself in that situation, obviously he's not going to leave the country. Well, I shouldn't say that. He may be in a situation where he doesn't have a choice. But most people, first of all, because the legislature specifically included exclusion from admission as one of the things that you should have been warned that if you didn't, you can vacate your plea in its entirety, the decision to travel, the affirmative decision to cross a United States border and leave this country should be theirs to make. And again, that's sort of beside the point of it may have this effect. The legislature's words are that if you show that you may have the effect, have the result of exclusion, well, certainly, if you never leave the country, with an important exception that I'll come back to, if you never leave the country, you probably won't be excluded. But if you do leave the country, you will absolutely be excluded. Now, there's another part of this case regarding the likelihood of the deportation itself as a necessary predecessor to the fact that you will, if you're deported, you will also be excluded. And in the Lydia Rodriguez case, the appeals court held, that that is a separate and distinct result that you should have been warned of.
Correct.
Now,
Well, wait a second. If you're deported, you're then excluded because you've been deported. You're not excluded because of the prior conviction.
That's correct, Your Honor. And
That's really a separate issue.
Well, it's related. In the Commonwealth versus Lydia Rodriguez, the appeals court held, I believe it was Justice Duffley's opinion, I believe, that because you will be excluded after you're deported, if you're warned that in Lydia Rodriguez's case, the person was warned about deportation, not warned about exclusion from admission.
So I'm sorry, I guess I didn't read that case. So if you're warned about deportation and indeed you're deported, and because of your deportation you are excluded, and you're not warned about exclusion, that doesn't make any sense to me.
Because you're not warned about exclusion. You're warned about deportation, but not exclusion.
You're not excluded because of the conviction. You're excluded because you've been deported, and deportation has its own exclusion rules.
Which was a direct result of the conviction.
Well, but no, you're excluded because you're deported.
If you're excluded, well, if you're deported only because of the conviction, then it still originates with the conviction.
I don't think that's what the legislature had in mind here.
Your Honor, to remember the purpose of the statute, it's to advise and inform an alien before they enter into a plea. It's to advise and inform them that this may have seriously adverse immigration consequences. And so if you're, and again, the bar is so low, you show that you may have these consequences. Well, statutory eligibility, and this is what's argued in the Committee for Public Counsel Service amicus brief, statutory eligibility, you're already in a situation where you may face that result. But beyond there, but we went beyond that.
What you're saying here is if the Immigration Service would today seize your client and proceed to deport him, that you would argue, aha, okay, fine. I was warned about deportation, but since then I will not be permitted to re-enter, then the conviction must be set aside.
That's correct, Your Honor. That's the holding of the Lydia Rodriguez case. But here, we're not limited to that because we specifically claimed, and the judge didn't deny this because she doesn't believe that he was bona fide in his desire to leave the country. There was nothing to indicate that. And frankly, it is not a remarkable claim that you want to leave the country for a lot of purposes. And a lot of those purposes, by the way, are time sensitive. Your family member dies, you want to go to that funeral. There's no time to litigate a motion. But here, the ultimate question is to demonstrate to the court that he may have the consequence of exclusion. Does he have to do it from outside of the country or inside the country in a jail because you haven't been admitted? But it goes further than that, Your Honor, because the legislature made a telling amendment in 2004. Originally, it was if you show that you may have the consequence. But in 2004, in response to, I believe, the Price case, they added if you may have or has had, because in Price, the court found that when you're already deported, it's too late to file this motion. It's too late. Now, 2004 corrected that. But there's a clear before and after. There's a clear, you haven't left yet. You haven't been excluded yet. You haven't been deported yet. It may happen, versus you're in the airport and you find you're being detained, or you're at the border and they tell you if you cross this border, you're not going to be let in, or you're applying for a visa in a foreign consulate, and they tell you, you're excluded, you can't come in. It already has had. So in terms of the legislative intent, may have is clearly the opposite in time to has had. Has had is after the fact. May have is a very soft, it's a very light burden of proof. It's almost like probable cause. In fact, it's even less than probable cause to give an analogous term in the criminal system.
Now, in Granum, we said it's not hypothetical if there's an express written policy of the federal immigration authorities that would call for the initiation of deportation proceedings, which in that case was the focus. Is there a express written policy of the federal immigration authorities calling for the initiation of exclusion proceedings against this individual?
Yes, Your Honor.
And what are you relying upon?
Well,
that affidavit, which is focused on deportation, or are you relying on the statute itself?
Well, the first step is the statute itself. The statute, 8 U.S. Code 1182, is clear that if you're convicted of an aggravated felony, in this case is an aggravated felony, you may not be admitted, period. And frankly, there's mandatory deportation. So the statute already is that written policy. Secondarily, Your Honor, there is also the Morton Memorandum, and that was attached to our original motion. It's part of the appendix. The Morton Memorandum is a statement of priorities on the part of the federal government of who they're going to reach out and get, who they're going to prioritize in removing. Certainly violent criminals are ahead in line, but all criminals, particularly aggravated felons, are in that top tier.
But that's focused only on deportation. I mean, that's a matter of who are we going to affirmatively seek to deport, and I thought we had discussed earlier that if you're coming into the country, you're in a different position than somebody who is still here and they're seeking affirmatively to deport.
Your Honor, it focuses on removal, and removal includes both deportation and exclusion from admission. When the immigration laws were amended, I believe this was the 1996-97 amendments, they combined exclusion from admission and deportation into one matter, which is you're being removed.
But
so it's about the priorities of a removal proceeding.
But it's also, isn't it, I mean, from your perspective, if we're talking about exclusion from admission, the statute is mandatory, and so you've got a sitting duck right there. Why? I mean, you would be violating the statute to let him in, right?
Absolutely,
as opposed to actually affirmatively going out and trying to find somebody and then initiating deportation proceedings.
Well, that's right, Your Honor, and I discussed that in my brief.
All right, thank you.
Thank you, Your Honors.
Good morning, Mr. Chief Justice, fellow justices. Jamie Michael Charles, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. As a preliminary matter, I would just like to note that this court would be perfectly entitled to affirm the denial of the defendant's motion on a completely separate ground, which is that the affidavit submitted in conjunction with his initial motion was, without question, not credible. I think if you look at this court's prior case law, it is entirely permissible, even in the context of a 29D challenge, for the court to evaluate the credibility of a defendant showing within his affidavit. And actually, on this point, the Commonwealth agrees with the defendant in representations he made at page 9 of his application for further appellate review, that a trial judge should be able to evaluate those representations. And here what we have is a defendant who did not say, I don't recall receiving warnings. We have a defendant who said under oath in an affidavit, I definitively did not receive any of my immigration warnings. And the Commonwealth subsequently, through reconstruction of the record, which it was permitted to do under Price, given the date of the defendant's plea, proved that he affirmatively lied about not receiving 2 of those 3 warnings. Additionally, you have a vague assertion in the affidavit, without any elaboration whatsoever, that after being in this country, based on what the record shows, for 3 decades, all of a sudden the defendant wants to travel and visit friends. So I would submit that on that scant record, based on an affidavit that demonstrates the defendant lied to the court, the judge would have been perfectly entitled.
There's no reason to think the judge did do that, though.
No, but this court is, as always,
why
permitted
don't
to
we get
affirm on
to-
any ground contained within the record.
Okay, I get that. Why don't we get to the issue that's really before us?
Absolutely. Turning to the issue presented, I would suggest that the appeals court has consistently and properly applied this court's holding in Berthold and Granum. The defendant must show that his conviction may have, well, for purposes of this defendant, as the statute read, may have one of the consequences of which he was not advised. And this court has held that there must be more than a hypothetical risk, or stated another way, that the defendant cannot withdraw his plea based on consequences that may occur in some hypothetical future.
Do you disagree that if he left, do you think it's really hypothetical that if he left this country and tried to come back, that he would be, you think that's hypothetical?
The Commonwealth is not disputing the hypothetical nature of whether he would be excluded if he left the country.
You agree that he would be?
I would agree that there is a statute that suggests he would be excluded if he left the country. I will absolutely agree with that. But what all 7 justices in Granum agreed is that a statutory basis for any one of these consequences occurring is not a sufficient basis to meet the standards set forth.
So the ground that you say that we should uphold is on, forget the lying part, but just that it's too hypothetical about the travel. Is that right?
Yes. The Commonwealth, admittedly, the Commonwealth does not have a finite standard to offer this court for what exactly is the requisite showing. These are very individualized cases, and they don't lend themselves to a clear standard. What the Commonwealth is suggesting is that the defendant's argument and the argument espoused by the Committee for Public Counsel Services in their amicus brief, that a mere statutory basis for any one of these consequences to occur must be insufficient, because that is essentially inviting this court to rubber stamp every motion to withdraw a plea where a defendant could theoretically suffer a consequence based on the existence of a statute. This court found that that was insufficient in Grantham, and I would submit that Justice Cowan's concurrence was prescient in that it recognized this future argument that defendants would inevitably argue that the mere statutory basis constitutes an express written policy and that that would entitle a defendant to withdraw their plea. But this court has said that that is not sufficient.
So, are you saying that the merely hypothetical nature of his dilemma is really under his total control because he doesn't have to leave this country?
Well, that is absolutely true, but it's not that fact alone that makes it hypothetical. I think you can take, with regards to this specific case, you can take into account the fact that based on this record, this individual has not left the country for 30 years.
What's
he has
the
been
point
here
of it?
for 3 decades.
How
So
do
to
we
suggest
know that?
now that he all of a sudden has this desire
I
to go
asked that
visit
question,
friends and
so
family.
how do you know that he's not left for 30 years? I asked that of counsel, and he said it's not in the record.
Well, pursuant to the defendant and CPCS's logic, had he ever left the country, there's no question he would have been
let
excluded.
back
He
in,
never
yeah.
would have been let back in. So he's still here. He must not have tried to leave, is the Commonwealth's
Why warn
suggestion.
about something if no one in their right mind are going to actually leave so they can be prevented from returning? What's the
I
point
don't think
of
that
warning?
that's true, Your Honor. I think many defendants
But there's
take
a
certain
statutory
steps
requirement.
necessary
Somebody
to
thought it was
challenge their,
important.
if the defendant wants to challenge his conviction, he's perfectly entitled to make himself known to authorities by applying for citizenship, to leave the country and go on a trip and take his chances. This court's amendment of the statute in 2004 permitted defendants who have suffered the consequence to still challenge their conviction. I would dispute my brother's characterization of that amendment. May have means at any point until you suffer the consequence. So when you receive a notice to appear, or when you file your application for citizenship, you still may suffer the consequence of denial of those things, because you have not actually suffered it until it has happened. Once you are deported, once you are denied re-entry, once you are denied naturalization, then the consequence has occurred. And now, under the statute as it exists, you still would have an avenue, even if you were no longer in the country, for someone to file a motion on your behalf and to have this plea withdrawn.
If his affidavit said, my mother, who was 97, just died in El Salvador, different result?
I think if we were presented with a circumstance like that, where a defendant made such a representation and backed it up with some sort of documentation, that this is I think this is inherently a fact-specific inquiry for a judge. You have to evaluate whether this is a credible assertion being made by a defendant. That is certainly a far cry from the case we have here. If a defendant
I just want to make clear, I want to make sure that, assuming that to be the case, I understand that's not this affidavit, but you would agree that if the affidavit had some concrete reason why this person, 27 years later, wants to / needs to leave the country, that there would be no question that he's shown he's highly likely to suffer this consequence of which he was not warned.
I think I understand the import of your question, Justice Botsford. The Commonwealth is not suggesting that every defendant must leave the country in order to be having a more than hypothetical risk of suffering. I can certainly envision circumstances where a motion judge would be satisfied that there has been a sufficient showing based on the circumstances you presented or some other concrete evidence. What the Commonwealth is suggesting is that the suggestion of this defendant in CPCS that a mere statutory basis for these consequences to occur, and even on the record of this case, that mere statutory basis coupled with a self-serving affidavit that a defendant is required to file as a matter of due course with a Rule 30 motion, where he files a one-sentence notion saying, I want to travel and see friends, is not a sufficient showing.
Well, what I'm really trying to make sure is that you agree. I think the defendant puts it well. There's sort of two questions here. One, what's the affidavit? And two, assuming the affidavit isn't the problem, is this a likely consequence? And I want to make sure you absolutely agree, absolutely it's a likely, in fact, it's a pretty inevitable consequence if he leaves the country. As opposed to, I take it, you would take the position, if he were to come in here today and say, I face deportation because, in fact, I have this aggravated felony on my record, it seems to me that's a different thing, because of course that depends on the ICE having the resources to be able to go find him and bring it.
I think I would agree with you that were he to leave the country, there's certainly a strong basis to argue based on federal statutes that he would be excluded. The only caveat I would give to that is that based on my brother's own argument, they suggest that this Morton Memorandum not only applies to deportation but to removal generally, which now, as I understand it, encompasses both deportation and exclusion from admission. And that memorandum clearly states that officials are to exercise discretion with regards to certain categories of individuals. Among them, people who are lawful permanent residents, people who are in relationships with United States citizens, people who have children who are United States citizens. The defendant falls into all of those boxes. He's in a 16-year relationship. It's probably longer now to the date that we're here, with an individual who is a citizen. They have 3 children together who are all citizens. He, based on his representations in his affidavit, is still a lawful permanent resident. So he checks off all the boxes. So I'm not entirely convinced that there would not be an avenue for discretion. I certainly will agree with you, though, that based on the statute itself, if he did elect to leave, there is a basis for his exclusion, and enforcement has ramped up, obviously, in recent years. So that I would agree with.
Does the same discretion apply if he were to leave the country and then seek re-entry?
Based on the record, in this case, it's unclear to the Commonwealth whether that is the case, so I can't give you a definitive answer. The only other thing I just wanted to emphasize is just for some context, and I realize it's not entirely relevant to the analysis itself, but this defendant has come before you 3 decades later saying that he is entitled to withdraw his plea. This was not a plea that was entered lightly. This defendant, along with several other co-defendants, were charged with larceny of a motor vehicle and subsequently led law enforcement authorities on a chase through multiple interstates, through multiple towns from Saugus to Newton, ultimately causing a crash on the interstate that resulted in the death of one civilian and the serious injury to another. Now, the defendant was not ultimately prosecuted for the deaths. The driver of the car was. But he was complicit in stealing that car, which ultimately resulted in this chase. He pled to a 5-year quote-unquote Concord sentence and served less than half of that before being released. I would submit to you, if this was a Padilla context, under no circumstance would any court conclude that this defendant would not have taken this plea and taken his chances at trial. He got a sweetheart deal.
But it's not. But this is not a Padilla.
No, I understand, Your Honor. But
so I mean, if he had committed murder, and he had not been advised of his rights, we would be obliged to say the plea has to be vacated.
I agree. Merely in providing context and assessing the credibility of this determination now, I would just suggest where it's clear that he lied in his affidavit and where it's clear that this far removed from the date of the offenses, it would be practically impossible for the Commonwealth to prove its case. He should not be able to just simply file a 1-line affidavit saying, I want to go on vacation, and be allowed to withdraw a plea that was really inured greatly to his benefit at the time he entered it. And I would say he has not made a showing in this case beyond demonstrating that there is a statute that exists, and that's it, because his affidavit is simply not credible in the context of the present record.
But what do we do with the catch-22 here? I mean, it is not credible to say that somebody is going to leave the country if they think they're likely not to be admitted upon their return. So, but yeah, he has not left the country, because if he did leave the country, and he would not be allowed back in. So the cost of leaving the country to visit family would be that you would lose your ability to live in this country. You want him to, I mean, how are you going to be, even if his parents were dying, he may say, I can't afford to leave the country because I can't come back. So how do we deal with credibility in a context in which the price of leaving the country is that you can't come back?
Well, I mean, I believe I addressed this to some degree with regard to Justice Botsford's question. I'm not suggesting that every defendant needs to leave the country to make this showing. I'm just saying that there needs to be more of a showing than the defendant made here. And inevitably, this will be a fact-specific evaluation for a trial judge, whether it was the original judge that accepted the plea or a new judge in light of a case like this where the plea judge has retired because so much time has passed, to evaluate the credibility of the assertions and hold a hearing if necessary. But on the present facts, the defendant, for numerous reasons, even if we were to credit his affidavit, I would submit that the allegations he raises within are not sufficient. But we know that he lied in this affidavit. It's not a credible showing. So all we're left with is a defendant essentially saying, and what CPCS argues in their amicus brief, there is a statutory basis for him to be excluded. Therefore, you should allow him to withdraw his plea. And that is a rubber stamp. That is asking this court to require no showing at all and to allow every defendant who pled guilty and did not receive the adequate warnings to withdraw his plea without any further showing whatsoever. And that is not what this court said is required in Berthold and Graham.
But the motion judge had the opportunity to assess credibility, didn't do it. We don't do that.
Well, she didn't hold a hearing. She determined on a separate ground based on Granum.
That's right, and so we can't determine the credibility of anything.
If this court were inclined, it could remand the case for a further hearing, and I'm fairly confident that the Commonwealth's position that this is not a credible affidavit would prevail. But there's no need to remand because even accepting the assertions set forth in the defendant's affidavit, he has not made a sufficient showing that he faces
So
more
you're
than a
just saying it
hypothetical
has nothing to
possibility.
do- Your argument really doesn't rest on the credibility at all, and it rests on the sufficiency, even if credible.
I think my argument rests on both. I think they're independent grounds on which this court can affirm the denial.
The problem you have with your Granum argument is that Granum sought it only on the basis of deportation. And as this defendant's situation demonstrates, the mere fact that the law says that you can be deported doesn't mean you will. There's obviously a discretionary question of how we're going to use our resources. But is that not different when the question is, do I, as the Homeland Security person, let this person into the country? I mean, why is that not a very different analysis than deportation?
Well, I would suggest initially that that's an unfair characterization of what the defendant is saying, because as I read the defendant's brief and the amicus brief, it is an undoubtable inevitability that he will be deported. That is how they present this. They say, okay, there is a statutory basis, enforcement has ramped up, he is inevitably going to be deported at some point, so even that in and of itself should be sufficient. But again, I would suggest on this record, we can't know that there won't be a basis for exercising some discretion for his reentry. And I would also submit that based on my understanding of the proceedings as they exist now, removal proceedings, individuals who are excluded at the border will be funneled into the same sort of proceedings that people who are deported are. So it's entirely possible he wouldn't be detained, he would just receive a notice to appear and then would go through the necessary process. This is the manner in which numerous other defendants, which have come before this court and the appeals court, have sought to challenge their convictions. There is a time frame during which, between the time in which you make yourself known to the authorities and you are deported, and you can file a motion, and it will certainly be more than hypothetical at that point that you're going to suffer the consequence before you even are excluded from the country. So there are numerous other avenues an individual can proceed through to validly challenge his conviction.
Basically, are you saying in order to avoid the label hypothetical, you have to put yourself in jeopardy?
I think I've repeatedly said that that's not what the Commonwealth is saying. I'm just saying that is one example of a circumstance.
You said making yourself known to the authorities. It seems to me that is just a
Well,
way.
that is one way in which you can challenge, but you could also make a much more substantive showing than this defendant did, that you have a credible need to leave the country for a particular reason. And something that is more than just your self-serving representation unsupported by any documentation or other evidence after 30 years of never leaving.
Why do you have to show that you need to leave the country as opposed to that you want to leave the country?
I'm suggesting that an individual's bare representation in an affidavit that they want to leave the country after 30 years of never doing so is not a credible representation that this court should find meets the standard.
So when they have asserted that there are family members they'd like to see, maybe it's time to see them. They're getting on in age.
Well, I suppose if it's been 30 years, probably you would like to see them, but wouldn't it suggest that you don't have a significant relationship with somebody, you're content to not visit for 3 decades?
I don't know.
It's a credibility assertion for the trial judge, and I would caution this court to set a concrete standard on this question. And for all the reasons stated, the Commonwealth would ask that this court affirm the motion judge's denial of the defendants.
All right, thank you. We'll take a morning break.